Hello, everyone. My name is Andrew Spear. I'm an attorney at Walters Gilbreth, and you are here today for a CLE on the changes to the Texas Rules of Civil Procedure. We're joined today by Andy Jones of the Sawicki Law Firm, Kristen Castaneda of Alexander, Dubose, and Jefferson, and Thad Spalding of Durham, Pettard, and Spalding LLP. Judge Redmond had an unavoidable emergency and can't join us today, but Mr. Spalding has stepped up and will be contributing greatly. Before we get into the changes, I'd like to introduce Megan McKinnon. She's a Diyl co-chair of the membership committee. She has a few words for us.
Thanks, Andrew. Yes, I just have a few announcements. As Andrew said, I'm a co-chair of the membership committee. First announcement is to sign up for the Diyl. Membership is due. Some of you may already be members, and if so, you'll need to renew. Renewals should be going out soon. If you're not, you can go to dayl.com. Under the membership tab, you can join there. When you get your DBA membership application, remember to click the box for Diyl. And if you have any questions, you can contact Sherry or ask your firm. The second is we're always looking for members to get involved at the committee level, and now is a great time to do that. If you're interested in getting involved in a committee, please contact Sherry. Sherry, can you provide your information in maybe the chat box, like your email? And that's all I have. So get involved. We always love new members, and contact us if you have any questions.
Thanks, Megan. All right, so our goal today is to just get as much input as we can on these changes. These are the most recent changes available to us. I have a red line copy, and we're going to start with Rule 47. So I'm going to do a quick screen share for everyone here, just so everyone can see what the actual changes are. And you'll see here Rule 47, and the big change here is they're upping that monetary relief cap from $100,000 to $250,000, and that does not include attorney's fees. Okay. And 47 and Rule 169 are kind of read together here. So I'm going to scroll down and you'll see 169. And it increases that cap, right, for expedited actions. Just give everyone a second here. And you can find this on the Supreme Court of Texas website. They're actually providing the red line to everyone. So I think this is going to keep things moving, or at least increase caseloads, and kind of, you know, have an impact on dockets. So does anyone have any input here? Andy, what do you think?
Yeah, so I want to start off, I think, with a couple of points. One is that I think a little context is important. If you look at the last legislative session, there was a change to our rules on county courts at law, specifically the raising the jurisdictional minimum, where you'd have to have, rather than 6 jurors, you'd have to have 12 jurors, and that went to $250,000. And there were some other key changes to the county courts at law in the last session that then now I think are tied to the changes here in these rules. And, you know, I'm a plaintiff's personal injury lawyer, so you could talk to me about, you know, certain lawmakers trying to reduce the number of increase the number of jurors because they think it's easier to win with 6 than 12. We can argue about that all day long. But I think the context is important, that now the expedited action rule matches the number of jurors, the increased number of jurors in county courts, and a number of those other changes that were made. So these two should be read together when you look, if you're looking at filing in county court. Okay. The other thing I'd say is that I think that this is, not being a judge, but I liked the expedited action rule before they made these changes. I could fire off a lawsuit in a smaller end car wreck and really move this case. My concern is that now that they've raised the limits, then this is going to get everything. And suddenly everything's going to be an expedited action with a 90-day trial setting with no teeth on the other end for when it's not met. And so dockets will be crowded, cases will pile up, and then we can talk about Rule 169 and its lack of exemptions. That's my other point. But to the two things I'd say to the prudent practitioner, look at your venue, look at your forum, make sure that you're looking at what rules apply in county court, because they dovetail with these changes. And that if you are thinking about how to plead these cases, this may get nearly every case, and you're really not going to have an expedited action. What you're going to end up having is a regular case with no discovery. That's just me.
Castaneda?
I agree with Andy. I think that this is a fix for something that wasn't broken and that actually was working very well. I know that there were people who sent in comments, and I will take a moment here to make a plug to everybody to stay involved in the rule making and rule amending process. I think, you know, a lot of times these amendments, particularly these amendments that we're discussing today, there were a lot of rules that were involved in these amendments. And I know that it's very easy for practitioners, myself included, to skip that part of the Texas Bar Journal where they're published, or not keep track of that on the Texas Supreme Court website. Or if we do read them, you know, we get outraged for a moment and then the phone rings and we have a call and we go back to the practice of law and don't submit any comments. Sometimes comments really aren't going to make a difference. The Texas Supreme Court has made its decision about what it wants to do. And unless there's some comment that wasn't thought of during the discussion process, it's not going to change. But I do think that there are times when an overwhelming response from practitioners does make the court stop and take notice and think about the fact that perhaps they have misjudged the way that a rule was being implemented in practice, or how it is going to impact, you know, practitioners' boots on the ground. So this is one of those situations where I do think that this is going to rope in a lot of cases that should not be litigated through the expedited process. I think equally it will rope in some additional cases that should have been, so it's not an all bad situation. I will note that, you know, the companion here, the Rule 169 standards for getting out of the process are notably vague and ambiguous. You know, you have to file a motion and show good cause. What's good cause? I don't know. Your guess is as good as mine. You know, we can take some direction from the rule itself and what expedited actions are made for. And certainly we can look to the case law and see, you know, what we can find. But I think that's going to be a very amorphous thing. And I think it's also going to vary from judge to judge what their standard for good cause is. So my bet is that we will see more motions under Rule 169, and we will start to plumb the depths of what good cause means and get more guidance from appellate courts and perhaps even the Texas Supreme Court. As you know, that process takes a while. So in the meantime, I would say think creatively and also be wary of the deadlines for making a motion to remove. You know, you can make a motion without leave for quite a while, but at some point you do have to have leave of court. And these are things that are good to discuss with your client early in a case where you know that you're going to be roped into the expedited process. You may not actually file a motion early, but shape expectations and talk and get the client's input. There may be things, especially early on in a case, that you're not really aware of from a business perspective or a personal perspective that would motivate you either to remove or to stay. So I encourage everybody to really keep this rule in mind, keep the procedures in mind, and have conversations with your client early.
Great. Mr. Spalding, you have any input on this, 47 and 169?
Yeah, let me add just a couple things. And to Kirsten's point, you know, if you saw the version of the rules that came out in August, it was significantly different to what ended up coming out in December. So some comments were heard and listened to on those rules. So it does help to participate in the process. As far as the change in limit, I mean, you know, I know Andy probably does, well, I know he does a lot of the expedited stuff on some of it, but from my perspective, I think you're going to see all the cases that were pled in excess of $100,000 before, those are all instantly going to become worth in excess of $250,000. Same case, but it'll be worth more, just to avoid that process. Because I think unless you're familiar with it, people fear it, so they're going to plead their way out of it. And I don't know. I mean, other than quick discovery, I don't know that you're going to trial fast. I don't know that anybody's going to trial fast. So, the risk you run with, which Kirsten touched on, is, you're going to get discovery done in whatever, 180 days, and then you're going to wait a year and a half for trial. And so the motion's going to come because, hey, it's been 8 months and, now we need to do some more discovery, or I need to supplement my client's medical expenses because she's still treating. So I don't know, practically speaking, that the rule changes necessarily make it any more attractive, and certainly current circumstances don't. But anyway, that's my 2 thoughts on that.
Well, and to follow up on that, Thad, is the other side of my practice, a large part is medical malpractice. And so Rule 169 used to have an exception for medical malpractice, certain real estate transactions, things of that nature, that you didn't have to, reevaluate your case at a higher value. You could take one strategy and say, because of the substantive issues in this case, because I've got to have medical experts, because we've got to take multiple depositions, because 15 interrogatories and 15 requests for production are not enough to litigate a medical malpractice case. You were out based on the subject matter. And I think that really hurts us as practitioners and as a bar overall, that we have made it about dollars and cents and not about legal subject matter. And this is and losing the legal subject matter exceptions, I think is really disappointing from Rule 169. And so that's one of my biggest concerns, is that we're sucking in cases based on dollar amount, not on subject matter. And that, I think, really waters down what we do as practitioners, and really, frankly, I think cheapens the practice of law, because, it's about dollars and cents, not about substantive law.
Speaking of dollars and cents, what about
one
the
thing I would
approval of attorney's fees?
Exactly.
Yeah.
Exactly. I would encourage y'all to set up a panel of judges for a year from now and talk to them about this, because I would be interested to hear judges' perspectives a year from now on what impact they've seen this actually have. Have they been inundated with motions to remove? Have they seen a lot more cases that are worth more than $250,000? All that kind of stuff. Right now, it's too early to say for any of us, but I do think that it would be interesting to hear from the judge's perspective whether they feel like this rule, was changed in a good way or not. Sorry, Andrew, I kind of jumped in there.
Well, putting it out there, just one more thing before we change to a different topic on Rule 169. I'd be interested to know if anybody here has heard of any good ideas on an enforcement mechanism for 169. It says that the judge can only continue it 90 days from the end of the discovery period or first trial setting, or I forget what it is. I don't see an enforcement mechanism. I don't see what you can do there. Anybody got any good ideas?
It reminds me almost of a TCPA claim with the mandatory hearing deadlines. And if it's not heard, I think you have to file your, request for findings of fact or conclusions of law or motion for new trial within 30 days, right? I practice family law, so this is not really my wheelhouse. That's what it reminds me of.
Yeah. Well, and especially, with the after effects of the delays in trials during the pandemic, we're all going to be dealing with that for a couple of years. So it may be a little bit, this may have a delayed impact here, because as that says, who's actually going to be going to trial. And it will be interesting to see, if all of a sudden we have an explosion of expedited actions, then there are going to be a lot more cases getting priority when trials start back up in person. And in addition to that, how do you prioritize among the expedited actions? So it's going to be sort of diluted. I think it might actually be diluted as well. But, it's just, this is kind of up in the air. But for purposes of everyday practice, just be aware that this does rope in a whole lot of cases and people who've never had to think about expedited actions before. Now you have to think about them.
That's true. Let's y'all want to move on?
One real quick point. I do have a fear that, and probably not anybody on this on this seminar, since you're actually on the seminar, but you're going to have a bunch of cases that are filed that inadvertently become expedited actions because they're pleading under the old rule. So get ready for some of that. And if you're on the other end of one, you may want to act quickly to move it out of it, so that you're not just, so that the parties are not inadvertently stuck on this on this freight train toward the end of discovery. So,
well, and don't just assume, to that point, don't just assume that because the plaintiff pleaded only over 100,000 that they wanted this to be expedited. You may be able to get an agreed motion to remove this from the expedited action track because of exactly what he just said.
All right. Speaking of expedited actions, let's move on to the new Rule 194. Okay, it kind of all ties in. And Rule 194 is, of course, your disclosures, and those are now renamed required disclosures, and they set deadlines for everything. So I'm going to do a quick screen share here for everyone on this new rule. And if you all saw the chat links, we have links to this actual document for everyone watching. Yeah, you see, it's no longer a request to disclose. Now it's the duty to disclose, right? And it's quite the rewrite here. They're due 30 days after the filing of a first answer. Okay, so there's new deadlines in play. You'll see time for initial disclosure. There it is. And then what you have to include. It's really quite a change, at least from our family law aspect it is. But we're going to focus on more of the pure civil aspects here. I'm going to stop the share. And what do y'all think of this one, 194? To me, I think this is the second biggest change, and I think it changes deadlines, and this is where everyone's going to mess up initially. That's what I think. Andy, you have any thoughts on it?
I've got lots of thoughts. That's probably why I was picked for the panel, right?
Yeah.
I think that ultimately, I think this is a positive step, but I think for most practitioners that were savvy to always put a request for disclosure in their original petition or
That's what I do.
Answer, this doesn't change, at least from a deadline standpoint, what was going on. That you knew you had to get your disclosure act together, or you wanted the opponents to get their disclosure act together from the outset. I think the devil is going to be in the details. And I think, unfortunately, and I think that, Kirsten and Thad as appellate lawyers can talk more detailed about it, but I worry that we're going to see more federal case law, federal decisions informing application of this rule in state court, because it reads a lot like the federal Rule 26 for disclosures. And I know we already do that for Rule 1, whatever it is, request for entry and inspection 196, which is like federal Rule 34 or whatever. And so that our Texas decisions have been informed by those federal cases. I'm concerned that that's going to happen again now on something that's used in every case for every case up and down the docket, as opposed to a more nuanced motion for entry and inspection. Just because I think we lose a little bit. I think that's an interesting academic point. So I'd be interested to hear what the appellate lawyers think about that. But so my initial thoughts are, this doesn't really change a lot of practice, at least this particular, that it's mandatory, but we're going to see some devil in the details, which we can talk about more.
Kirsten, you have any thoughts on this?
I think it's important to keep in mind that although it is a duty without waiting for a request to disclose information, and there is a quite early deadline for it, this rule is subject to the same principles as every other discovery rule, in that If you don't have all the information at the time that your response or your disclosure is required, you have the ability to supplement as things come to light. Having said that, this rule includes some sweeping disclosures that mean that lawyers on both sides have to keep a much closer eye and a tighter rein on what is coming to light and how quickly do you need to supplement your disclosures, knowing that we're not talking here about, oh, well, I had it, but the other side didn't ask for it, so I had no duty to actually, produce it or disclose it. The two biggest categories here that I think are going to cause problems for people are B4 regarding damages and B6 requiring disclosure of a copy or a description by category and location of all documents, ESI, and tangible things that the responding party has in its possession, custody, or control and may use to support its claims or defenses, unless the use would be solely for impeachment. So pretty much anything you might want to bring up at trial, you now have a duty to just disclose it, either produce it or describe it by category and location in a way that the other side isn't going to say was completely misleading or vague and ambiguous. So again, as things are coming to light during discovery, just as this rule is going to be subject to the general principles that you can only give what you have at the time, but then you have to supplement reasonably promptly. It's also going to be subject to the rules that say if you don't supplement at a time that the rules consider reasonably prompt, you are subject to have the sanction of not being able to seek it or use it. So if you leave out a damages calculation because your expert came up with it, and then fairly late in the process, and then maybe there's a report, maybe there's a deposition, maybe there's not, and you forget to supplement the damages piece with that extra information, where are you in terms of actually being able to seek that at trial? Yes, maybe you have an argument if there was a deposition. There is some case law out there that you had a deposition, you gave out the information, so you didn't technically supplement your disclosures. What does that mean? But even those cases don't say, unequivocally, oh, hey, you gave them the information in some other way, so you're off the hook. Even those cases make it clear that judges have discretion in this area. So I just think that the new disclosure, in addition to what Andy said, which I agree, what he said about, getting into the federal interpretive case law, just remember that you're going to have to keep a closer eye on all of this. And if you are the one running the case and you don't have the luxury of having an associate or a paralegal who's sort of backing you up, I strongly suggest checklists, timelines, whatever you can use as a tool in your tool belt. Have a pre-trial notebook that you're using. Whatever tools you need in order to keep up with this, I would advise you to add those to what you do in trial prep. It will save you a huge headache, and it'll save you having to call appellate lawyers at any part during the process.
We have just a quick question here from Gabrielle Shayeb. With respect to the time limitations of the new rule redisclosures, are any discovery requests served prematurely considered void?
Oh, that's a great question, because I just filed a suit last week where I still served my discovery with it, but I put in the line, instead of saying per this rule it's due within 50 days, I put in that it's due within 30 days of the original of the first filed answer. See this rule. So my thought on that was that I can give it to you whenever I want to. The due date has just changed. So that was my take, and I just did that. So if the defense lawyer in this case is out there, come at me, bro. Let's go.
Thad, what do you think?
I mean, it may be, you may have to take the position that it's like Andy's talking about, it's deemed served on you whatever the timeline is provided by the rules. But yeah, I mean, you can't serve it until the required disclosures are either due or have been made. I'm not even sure what the deadline is. But yeah, I don't know if you have to reserve them. I think they would be deemed served on you, and then you'd have 30 days from then to get them done. But yeah, I mean, and this is definitely an effort by the Supreme Court to push us more towards the federal court practice. So if you have experience in federal court, doing this kind of stuff, it will be helpful, but it's still different, because in federal court, you don't have to do any of that stuff until you have a scheduling conference. And so usually there's a scheduling order, or there's some sort of order from the court saying, okay, everybody, here's when you have to get your disclosures to each other. And so there's a deadline set. This deadline, this kind of default deadline that's tied to when an answer is due or a general appearance, that's going to get messy, because not only is that the defendant's deadline, but it's the plaintiff's deadline too. So, plaintiffs, unlike prior situations where you could just send the request for disclosures and then you'd get stuff back, now you're going to have to do that too. And you're going to have to do it by that same deadline. So I think what's going to happen, or what I would want to do in a case, is you can alter these deadlines by agreement or court order. And so if you as the plaintiff aren't ready to produce all your documents, then you call the defendant and go, hey, let's push this off 30 days. And I think, like Kirsten was saying, let's see what the judges think of this a year from now. I think you're going to start having orders, like some judges do. You're either scheduling orders or at least some sort of preliminary scheduling order as soon as the defendant's answer, saying, okay, here's your initial disclosure. Everybody's initial disclosures are due on such and such a date, and we're gonna have a status conference or something like that to make sure everybody's on the same page about how all this is going to work.
That reminds me of local rules in some cases, right? Maybe the courts will just start imposing those and are updating them to match up.
Well, Kirsten's point's a good one. Is depending on when this deadline is, and now that you actually have to produce or at least identify all your documents, it's going to set up a lot of fights under 193.6 about excluding stuff. It's not, your obligation to disclose it is right at the beginning of the case. Yep. And if you're supplementing it 30 days from trial, but you can't say, oh, I didn't know I had it. I just found this. That's going to be a tough argument to make.
Try to weasel out of it by saying may use. I didn't know if I would use it. Maybe something like that, right?
Well, but that's the problem, is that may use makes it so that even if you thought there was a possibility that you might, under some circumstances, use it, you have a duty to disclose it. It doesn't say that you will use. So you don't really have a whole lot of wiggle room. I would encourage people to remember that there already is a Rule 166, very seldom used under the Rules of Civil Procedure, that provides for pretrial conferences. This doesn't help you early on in the case, because it truly is supposed to be a pretrial conference. If you look at all the documents or all the items that you could discuss at a pretrial conference, it really is, getting ready for trial. But there's nothing that says that pretrial conference has to happen, the week before trial or 2 weeks before trial or even 30 days before trial. If you feel like, discovery is closed, but you have a trial setting, but it's pretty far off, and it would be helpful to get in front of the trial court to just raise some issues that are still outstanding. That's a mechanism to use. If you need a scheduling conference or a status conference or something of that nature before discovery closes, for example, to discuss some of the things that Andy and Thad were talking about, I would encourage you to take the benefit of Zoom conferences and, inquire with the court coordinator as to whether the court would be open to a, 15-minute status conference just to go over where we are in the scheduling order and to talk about some issues that have arisen in discovery and get the court's guidance. Not full-blown motions. Nobody has to spend the money on that. equally, the court doesn't have to spend the time, boning up on a notebook full of motions and responses. The parties are trying to confer and they're trying to resolve things, but we could use the court's guidance on several issues to help us get to that resolution and hopefully not have to bother the court with motions. Some judges are going to shut that down or not be interested in it. Others will be very open to it. And I think, if we're all going to have to deal with the downsides of pandemic life and Zoom conferences, let's all take advantage of the upside. And that is sometimes it's easier to get 15 minutes in front of a judge because not everybody has to trot down to the courthouse and be available at the same time. It can be, everybody's sitting in their dining rooms and their bedrooms and their offices coming together. And I think having a status conference also does encourage the process of talking between the sides. Let's just assume that every single person on this seminar is the person who's really trying to resolve things and that our opponents are the ones that are standing in the way. Setting up a status conference can help you because it sort of forces, by putting a little bit of accountability on the other side, for them to talk to you before the status conference and maybe get a little further along in some of these things that we all know ought to be resolved between the parties without emotion. And then it also, when you get guidance from the court, sometimes that helps too. So don't forget about 166 that's already available to you, and the fact that many judges are open to quick status conferences that do not require them to review a notebook of materials in advance.
Ghost, I think that we're also going to see on this request for disclosure, or the required disclosures, is old Rule 169, or I'm sorry, old Rule 190.2, the level 1 discovery rules.
Yes.
It had a requirement in there that you had to disclose all documents, electronic information, and tangible items that the disclosing party has in its possession, custody, or control, and may use at trial. So the case law there, and that was an experience some of us had used before. I think that's also going to be telling and kind of haunt the new Rule 169 and the disclosures. And so like I said at the top, I'd be interested in seeing the tension between rule made under 169, Rule 190 about that disclosure, and federal rules and federal disclosures, and how we're going to resolve those, and what that practice is going to be in light of where we used to be and where we're going.
Well,
sorry, just one quick note for this particular audience. I think all the stuff that we're talking about right here is an area where young lawyers are really going to prove their worth and add value. I mean, as a young lawyer, you're looking for ways to make yourself the expert on things without, overreaching. There are going to be a lot of us old timers who are not familiar with the rule changes. I have conversations every week with people who are not aware that amendments have actually happened. You guys are going to be the ones who know all the ins and outs of this. And even if you don't have definitive answers to things, as you're seeing from all of this discussion, there are no definitive answers to many of these things. There are only sort of options, and there are risks, and there are sources that you can go to, like the federal case law for the new disclosure requirements and things like that. So look at this as a great opportunity for you to be the expert on these rule changes and on what the options are, and sort of like, what would your recommendation be to solve this problem or to address that? And how can you, as the younger lawyer on the file, if that's your role, how can you keep up with, okay, by the way, we just got this new batch of documents in for the client. Do you want me to go through them and see if there's anything we need to supplement our disclosures? Because I guarantee you there are going to be older lawyers who are not thinking that way. So this is a real opportunity for you to show what you can bring to the party, and for you to own your work as if you're a partner, to own your work as if you're a 30-year lawyer. Because you're going to be the one probably of everybody who is best studied in all of this, and who's had the chance to go to multiple panels and gather the wisdom of various people to say, here's what I think we should do, but here are some other options I've heard.
Yeah. Keep in mind that when your old supervising lawyer comes to you and asks you about the new discovery rules, they may be referring to the 1999 changes to the discovery rules. So you might take that out. You can take that opportunity to educate them about the new discovery rules.
Well, and on the flip side there for that, Thad, is I now enjoy, as a young lawyer, being able to say, well, under the old rules, you know.
Well, moving along with the rules, Andy, you had a great segue earlier into 190 and 192. And this is just discovery levels and when the discovery periods start and end, which is another change. So I'm going to do another screen share here. Let's hope I did it right. There's Zoom questions. Don't want to see that. 192.2 is going to open the door for 190. So you'll see here. Party cannot serve discovery until after the other party's initial disclosures are due. It's 192.2. We go up to 190.1, right? 190.2. At 190.2, level 1, right? 90.3 is level 2, of course, and 190. We'll hold on here. Yep, those are the two big ones. And we all know level 3 is its own little beast. So discovery periods change now with these RFDs. I guess I can't call them an RFD anymore. Can't I? Required disclosure, right? What do y'all think of this? I have to wait now, right, before I can send you anything.
Well, that's what I said. That my thing about earlier in the good question from the audience. I think that this is a trap. You know, Admiral Akbar is up here telling me this is a trap because I file my petition and then it says, oh, I can't serve discovery until after the initial disclosures, da-da-da-da. I'm so busy getting my initial disclosures together, I never do send you discovery. Not Andy Jones, but imprudent and unreasonable lawyer out there gets caught in this trap because they've been practicing it the old way so long that this new thing comes along where there's a fight where there shouldn't be one and there's a trap for the unwary, which is why, at least on this one case, I've decided to try it one way and maybe on a different case, I'll try it another to see what happens because nobody knows what's going to happen. But I think that with this trap, you have to get around this trap. And I think one reasonable way is to say, I've served you with them, but they're not due until this certain time. Rule says you can't be served with them. Okay, well, got them. I'll send you a letter that says I'm reserving them. You know, otherwise you get caught. You could get caught in that trap where you never sent discovery because of the way the practice has changed based on these changes.
Sure.
I mean, I think the rule literally prohibits you from serving discovery until after initial disclosures are due. But I do agree with Andy that to the extent that you're having this fight in front of a judge, the judge is going to just be so annoyed that you're even there. If I were served discovery with the petition, I would send a letter. Well, I guess I'd have to be careful. I don't know what I would do exactly, but I guess once I served, I'll tell you what I would do. When I served my initial disclosures, I would also send a letter saying, hey, my initial disclosures were due here. You served me discovery before that. I'm going to pretend like you served it to me on this date. And so my response is due on this other date and, you know, go from there. I wouldn't even necessarily ask for a Rule 11 on it. I'd just say, here's what the rules provide. I guess I would be wary of sending a letter before I answered or something like that. But I mean, once I'm sending my initial disclosures, I think at that point it's fine to say, basically, I'm going to treat these as deemed served when the initial disclosures are due. And that's how I'm going to respond. I think anybody who tries to go in front of a court and say, they served them before initial disclosures were due, so they're void, and I'm not going to respond to them at all, and they need to serve them once again, you're just going to lose some credibility.
What do y'all think about under level 1? They've increased depositions now, right, from 6 hours to 20, and also, I guess I have to wait until I start deposing people too, right?
Well, good luck getting your med-mal case done in 20 hours.
We'll see what happens with that. Thad, what do you think about this change?
Well, somebody, and I'm not sure I've necessarily confirmed this yet, but I was listening to someone talk about the rules yesterday. Oh, I was listening to Paul Gold talk about the rules in Houston yesterday, and he said there's a distinction between the time under level 1 that now expands it to 20 hours for each party, and that later on in the rules, the old limit of 50 hours is per side. So, you know, in a case where you have a lot of defendants or a lot of plaintiffs, you know, you may technically have be entitled to more deposition time under level 1 than you do under level 3. I'm not sure if that's the way it'll play out, but that's at least the way it reads.
I think it's interesting how much they've also expanded level 1 greatly. Normally, I don't think I have many cases that fell in level 1, but now there may be more, especially under these new rules. And also under level 1, the discovery period ends 180 days after the initial disclosures are due, right? So that's another trap everyone needs to look out for, right? Where the younger lawyers can have a one up there if they just keep it in their sites.
Well, that's you know. Oh, go ahead, Andy.
I'm sorry. I'm just going to beat the drum one more time for that.
Yeah.
This is a money-based thing and not a subject matter-based thing, because I think that this is also, we're going to get into trap for practitioners who used to think, oh, well, this subject matter doesn't apply here because of the complexities and the nuances. And they're really about the dollars and cents thing. So then we're going to start going at hearings with judges to ask for more time or ask for this or ask to do that. And we're just going to have a whole bunch of fights where there weren't before because we had exceptions into the rule. So that drum has been beat. I'll step off it and let Thad go.
Well, my only thought was, you know, given some of the points some of the issues we've already pointed out with regard to disclosure timing and all that kind of stuff, I think you're going to see a lot of courts enter orders. And so as soon as they enter orders, it's no longer a level 1 case anymore. It's now a level 3. And so, you know, you may not, that may be the at least from a predictability standpoint, that may be the better way to go anyway. So you can kind of control your own destiny. Because level 1, you know, my experience with level 1 is, I mean, unless you were really on top of it, you always ended up in some position where you hadn't gone to trial, you were nowhere close to going to trial, but discovery ended 6 months ago. And somebody didn't want you to do any more discovery. And then you're arguing about it. So, and that hasn't gone away in level 1. So I think maybe we might see more. I think it's just an added incentive for judges to yank it out of level 1 with some sort of pretrial disclosure order requirement deadline.
I will say that if you're trying to get your case out of level 1 and you haven't gotten any of the benefits of the stuff that Andy and Thad have been talking about, where the problem is sort of taken care of for you because the judge enters an order or something happens along those lines, you do need to make sure that your motion has detail. I don't know that you need to go into the level of detail that a motion for continuance of trial would require. But because this change has been made, and because, for example, all of the medical malpractice exception is out, I don't think that you can get removed from level 1 just by saying, hey, this is a medical malpractice case. And by definition, that just takes a whole lot more work, because the response to that is, well, the Texas Supreme Court knew that when it changed the rule, so give me something else. So I wouldn't rely just on this is going to take a whole lot of work or I need a whole lot more discovery. I think you're going to have to provide some detail in terms of who do you need to depose and why. And what documents do you need and why? And what interrogatories do you need to ask and why? Do you need to marshal everything? No, but you need to provide more detail than just this kind of case requires a lot more discovery than I'm getting. And you probably need to include evidence with that. So, and the evidence may be an affidavit, or if you're required to have an evidentiary hearing, it may require, you know, the lawyer providing the same sort of evidence that would have been in an affidavit. But don't just sort of go on rote and think that saying everybody knows this kind of case requires a lot more discovery is going to actually support your motion. You may prevail on that motion. You may have a very favorable judge, but if you don't, I think that kind of approach is just going to get a flat denial, and you're not really going to have any option Not that you would necessarily mandamus, but if you were going to, you would not have the record you needed to take it up.
Well, and a big concern I have on this, the whole monetary value versus subject matter thing, is that, and I need to see the rule again just to make sure, but I'm worried that there are going to be opportunistic battles over, well, you've pled it as a over 250. Well, I'm moving to oppose that. Well, this should be a level 1 case. So now you have to prove to me that your case is properly pleaded over 250, kind of like federal amount in controversy fights. And so I feel like, again, we're inviting fights where there were none, and that no one on the seminar is going to do it, of course, but it might present opportunities to be obstructionist or challenge things that weren't issues before that may not necessarily have merit, but you can because it's what the rules say. And I have a big concern there about challenging the jurisdictional limits, the 250, the 100, that sort of thing.
We can briefly talk about, though, there are a few exemptions on 194.2. I'll pull that up for everyone. It's remotely on topic here. It's exemptions for the disclosures. 192.4D, and I think we talked about these very briefly earlier. Here's another screen share for everyone. It'll work. There we go. Review of an administrative record, forfeiture actions arising from a state statute, habeas corpus proceedings, a 4D family law case. There are those. There we go. I don't know. I can understand why some of these might be exempt. Maybe it's because, if it's a habeas corpus proceeding, that might be extremely expedited in some cases, right? Or, a 4D agency case is the Attorney General child support cases. So, I can understand why that's exempt. But administrative records, I'm not sure. What do you guys think about these? Andy, nothing? Yeah.
Not my area of practice on that one. I'd rather talk to you about the changes to the expert disclosures.
We can do that.
That's going to be on fire right there.
The expert disclosures, that's 195.2, right? Is that where you're going with that?
Well, and it's more that I can write to my expert what I want him to say, but say that it's not facts or evidence and it's not protected. I'm not doing that, but I think we're going to have a fight about the changes to 195C, is that expert communications are now privileged. Again, like they were under the federal rules. So we're going to be pulling in federal cases and stuff like that. But now we're going to be having fights over, well, I sent my expert a letter about some of this stuff, or I texted my expert about something, but no, it wasn't about the facts that he's relying on in this case. We're going to be getting into a lot of battles on this. And I think that we're going to be looking to federal case law on how to decide some of this stuff. But it is a significant change for our rules on how you interact with experts and what experts are required to disclose.
Yeah, and I pulled that up for everyone here. It's under 195.5C. I believe that's what Andy is discussing there. Kristen, what do you think?
Well, I mean, I think that that certainly the new requirement that you disclose all of your experts' information as part of the required disclosure. So now we're not waiting for the request, and you have the duty to do this just, whenever you designate your expert. That's really important. I would imagine that, just as with the previous version of the rule, if you got served a request for disclosures with the petition, and so you did have a duty at the outset to make disclosures, most people aren't disclosing experts at that point in time because they don't have their testifying experts lined up. So I don't think that there's going to be a huge shift in terms of people having to keep an eye on this and that sort of thing. But I do think that it is, there's some significant changes here, and there's room for gamesmanship. But But I also think that this is going to be a time when we're all getting back into the case law that talks about, discovery is, the purpose of discovery is to reveal, not conceal the truth. And we're going to be going back to that. So for people who are considering whether to engage in gamesmanship or to try and test the boundaries, I would encourage you to just think about how that's going to impact your credibility with the court, how that's going to impact the case itself. If you engage in this gamesmanship, is that going to create delay because there's going to be motions and hearings and then possibly orders to supplement discovery or orders to do whatever the court may require you to do? And then that's going to add time onto the timeline. Maybe right now where we have this delay in trials, it's not as big of a deal, but in 3 years, it probably will be a big deal again. Are the expert issues the first thing that you're really going to appear before the court on? Maybe you haven't had a whole lot of other discovery disputes, and this is really going to be the first big fight. Do you really want the first big fight to be you're trying to hide things and skirt things? And also realize that as much as these rules are a change for practitioners, they're also a change for judges. And particularly if you're in front of a judge who's been on the bench for 25 years, I'm not suggesting that the judges are going to refuse to apply the new rules, but I do think that they're going to apply the new rules in the context of how we've all been, working in the past. And so their reading of the new rules is probably going to be more consistent with the general principles of discovery and the way things have been going than it will be just to say, it's the Wild West now, and we can all hide a bunch of stuff that we couldn't hide before. So just be cautious, I would say. Once there's some case law out there, if it turns out that yes, indeed, you can do this, that, and the other, and it's okay under the new rules, and the Supreme Court leaves the rules as they are, then you know what? You have to zealously defend or prosecute a case for your client, and you go where the rules allow you to go. But until then, I would just be cautious about how much, if it seems to you like gamesmanship, it probably is. And that's where knowing your judge and understanding your court and understanding how far you can push the envelope is going to be really helpful.
Well, and Kristen, to that point, that's one of my greatest concerns with some of this expert stuff is that the rule used to be much clearer. It used to be black and white on what the responsibilities were. And so we are all called to a higher place. We have duties that go above and beyond the rules. But my concern is that when you change a black and white rule, there will be the opportunity for it to be misused. And so I think we're going to need a lot of guidance, like you've pointed out. There's going to need to be a lot of guidance where maybe there wasn't like you said at the beginning, it wasn't broken, so why did we fix it? But
well, I think if you look, pay particular attention to the comments because they're all referring to the particular federal counterpart to it. So, explicitly under the rule, that's what they're meaning to do. And so, to the extent there's authority that helps or hurts you, it's going to be good to know about it. Now, Andy, you said something earlier. You referenced this provision as expert communications being privileged. I had not read it as a privilege, but I mean, it kind of reads like it. And so, I mean, do you think that it is, because in federal court, I've always taken the position that I just don't have to disclose it. And so all they get is the final report. They don't get drafts that my expert prepared.
Right.
If I think there's an argument that, maybe it's treated as a privilege. And the reason that concerns me is because if it's treated as a privilege, you have to identify it.
Right. And I can't remember where I was reading this, but I felt like in federal court, there were some courts that suggested that the expert stuff like that might have fallen under anticipation of litigation and work product privilege, as opposed to just flat out, you don't get it. And so I may just have not read it, and that's why I defer to you as an appellate lawyer. But I think that, yeah, again, here's another issue you've identified, which is, does it read like a privilege? Is it a direct exemption? How are we going to apply that? What are we going to have to do? And again, where we had a rule, where the rule was before, you got to give me everything. Now it's this question. And so we're going to be having a whole lot of expensive, difficult, and pedantic fights where there wasn't necessarily needed to be one. But, you know, I'm sure that the federal rules will have good answers for us, and we'll, you know, go along our merry way, and it'll be fine.
Well, and I think one place to look for that, I agree with y'all that I think it's written ambiguously. It doesn't, you know, in the expert rule, it talks about how certain things are protected from discovery. It doesn't say they're outside the scope of discovery, in which case, clearly I would think that you would be right, that this is just outside the scope of discovery and I don't have to assert a privilege. It's just not discoverable. If you look at 192.5 D, 192.5 talks about work product, and it talks about it in terms of protection the same way as the expert rule, and it says that core work product is not discoverable. And so it's a little, you know, it's a little bit ambiguous. But then in 192.5 D, there's a subsection called privilege, and it expressly says, for purposes of these rules, an assertion that material or information is work product is an assertion of privilege. So all of us know from that, there's a privilege, you have to assert it. And I don't see anything in the expert rule that says that. And
except under Rule 193, where you don't have to disclose attorney work product.
No, but what I'm saying is there's an express statement in the rules that says this is a privilege. And therefore, I know as a practitioner that this rule has said it's a privilege. So whenever the rules require me to assert a privilege, this is something I got to assert. So when it tells me in the in 193.3, good segue to there, maybe to finish up, that I have to, you know, I need to assert a privilege. I need to, if I'm withholding information pursuant to a privilege, I have to let you know that. Then 192.5 D has expressly told me work product is included in that. You got to do it. And so I think there's an argument to y'all's point. I don't think that the rules are clear right now about whether the expert protections from discovery are, this is outside discovery, you don't even have to provide it, or this is a privilege and you have to assert it. I would argue if it doesn't expressly in this rule include something akin to subsection D in work product, it's not a privilege. But again, everybody's sort of, you know, taking these risks. So you got to decide, you know, whether perhaps you want to just put in a boilerplate that says, you know, in your expert disclosure, you know, expert communications under 195.5C and draft expert reports under 195.5 D are protected from discovery and will not be produced. And just leave it at that and see what that gets you. You're not saying you've withheld, but you're saying you're not producing them. And, you know, at least you've alerted the other side that you're abiding by those things. I do think that, you know, there have been some changes to the way privilege clawback works. I know we only have a couple minutes, but I think, you know, one of the questions that Andrew had raised was, you know, the clawback language talks about any party. And so does that extend to, you know, just everybody who may have received information? And I think if you look to elsewhere in the rule where it talks about discovery from non-parties, and I've had it and then I lost it. It's in the 200s, I think. Yeah, 205, discovery from non-parties, and talking about how a party may compel discovery from a non-party that is a party who is not a part, that is a person who is not a party or subject to a party's control. I think that sort of puts the party language in the privilege rule into context. And people can make their arguments about what that means and how broad the clawback is. But I think when you have another rule that speaks about non-parties and defines them, that may help in people's interpreting the scope of the clawback in 193.3.
Okay. Well, we're at 12:59, everyone. I think we've reached the end of the panel today in the CLE. I'd like to thank all of you for coming. I'd like to thank Mr. Spalding. Thad, thank you very much for stepping up and jumping in. Ms. Castaneda, thank you again. Mr. Jones, thank you as well. And everybody, if you look in the comments, I believe Sherry had put the CLE code in case you need to enter it. And there's a few answered questions in there as well. So thanks, everyone.